others.
My Lords, I appear with Mr. Naylor on behalf of the insurer in the appeal against the judges finding the preliminary issues in the Mayfair case. Mr. Fawcett is for Mayfair, policyholder. I think there's a little bit of nervousness on the part of the next case, the Why Not Bar case, as to whether they might get called on this morning. So I was asked if it would be possible for the court to give an indication that that wouldn't be before 2 o'clock. I only mention that in case you move us along quickly and we actually finish before then, in which case we would come over and be ready to do.
Well, looking at the timetable, I think you're due to finish by about 12:30.
Yeah.
And Mr. Fawcett has just over an hour. So if you're both going to stick to that timetable,
just in case we're even quicker than
then it looks as if they're safe.
Yeah.
Okay.
Right,
well, let's review it at the break, shall we? But it looks as if they.
Thank you.
My Lord, if I may, I may finish before 1 o'clock. I can't promise for certain, but I don't.
Well, if we're only going to finish shortly before 1 o'clock with you, then we'll start the next people at 2 o'clock.
Thank you. I propose to address you on causation grounds 2 to 4, and Mr. Naylor will follow on ground 1 in relation to the meaning of suffered.
Yes.
Preliminary issues and the judge's answers in Mayfair are issues 13 to 16, and the reference, which we don't have to turn up, is CB 28467. The policy schedule is at CB E 41822. I would ask for that to be brought up. The Mayfair disease clause is at page 829. If we could go to that, please. And if it's possible for CPM 10 to be enlarged. Thank you. So this is the clause that's the subject of dispute. CPM 10, murder, suicide and infectious disease extension, 2006. Section B, loss of profits is extended to include losses arising from the closure of the premises by a competent authority due to a human notifiable infectious disease or food poisoning suffered by any visitor or employee, or by defective sanitation, vermin or pests at the premises as specified in the schedule, or by murder or suicide occurring at the premises. Now, I'll come back to that momentarily, but just to put it in the broader context. See also page 825. If we look at page 825 to 828 to give you the relevant cover details. So 825 indicates the period of insurance, 8th of August 2019 to the 24th of March 2020.
Yes.
If we could scroll down and go over to the next page, please. And that gives the sum insured, which you'll see for the loss of gross profits was 6 million. If we could go to 835 of the schedule, please. At the top of the page, there's a reminder. We'll remind you of your obligations under the Health and Safety at Work Act 1974 to protect the health, safety and welfare of your employees, which includes workplace risk assessments and at the bottom, communication of health and safety procedures. And then turning to the policy, if we could have core bundle page 763, please. And if we could have that enlarged, please. And the point that I would highlight here is the definition of the insured, which means the person, company, or firm named as the insured in the schedule. So it's not confined to corporates, entities, it covers sole traders and partners. So that's who it addresses. In this case, the policyholder was a corporate entity, but the policy identifies that its provision is relating to entities of those sort. The definition of premises at 763 is further down, if we could scroll down. Premises stated in the schedule, or any premises within the situation stated in the schedule. And then just for completeness, at 775, is where the business interruption section starts, and that goes through to page 782. Now, if we can go back to the Mayfair disease wording at core bundle 829.
So just before you just said premises,
Yeah,
contemplates that the assured premises may be within a situation which is described more widely in the schedule as, say, the whole building.
yes,
So at the premises and at the premises peril might involve an occurrence which is not at the assured premises. Is that right?
that's possible depending how the schedule.
Depending on how the situation is described.
Exactly. In this case, if we go back, it's defined as, it's given a specificity, but I think your lordship is right. So other cases, the schedule, there may be a slight difference between what's being said in the policy and how it's put in the schedule. Yes.
Thank you.
If you can go back to page 829, core bundle. And this is the disease policy. And the specific question of the subject of the dispute is the words that are claimed to be engaged by the loss event, which was the national closure of businesses, including nightclubs, on the 20th of March. Which follows the interpreted the words losses arising from the closure of the premises by a competent authority due to a human notifiable infectious disease suffered by any visitor or employee at the premises. So that's agreed to be the relevant words that are the subject of the dispute. So the premises is applying to the disease question, and the object of the exercise is to understand what's meant by closure of premises by competent authority due to a human notifiable infectious disease suffered by any visitor or employee at the premises. It's a disease hybrid.
So it's common ground that the at the premises wording qualifies the human notifiable infectious disease suffered by a visitor or employee.
Yes, that was clarified at trial. It's been accepted on the pleadings, and that's the position, yes.
Okay.
Now, it's a disease hybrid clause, so it's a clause stipulating that disease circumstances in a place needs to cause something else. Here, the authority closure of the business. And the Supreme Court in FCA and Arch, don't think I need to go to it, but the reference is paragraph 214, Authorities Bundles 188, who said in relation to hybrid clauses, the structure of these clauses is that the elements of the clause are required to operate in a causal sequence. The Mayfair Disease Clause contains 3 elements. Element 1 is the required outcome, closure of the premises by a competent authority. Element 2 is the causal link. The closure needs to be due to something. Element 3, the circumstances that have to do the causing. Here, any visitor or employee at the premises suffering a notifiable infectious disease at the premises. And we say that element 3, the disease circumstances specified, has to be a cause, underline a cause of element 1, the authority closure. The reason for that is that element 2, the causal words, due. Now, put at that level, it's not esoteric, it's not difficult for the ordinary policyholder reading it to understand and to agree to take the policy with that causal requirement. It's drafted clearly enough. The policyholder won't be bamboozled by this stipulated causal requirement. People have an innate sense of understanding of basic cause and effect. We're not all philosophers. We don't all delve into the undergrowth of it, but people do have an understanding about cause at a basic level. And an ordinary policyholder reading that would see that there was a causal requirement. And for that reason, anyone who's interpreting this provision, where they're trying to do so looking at the matter through that perspective, should take that seriously. Now, we say that what this provision means is that element 3, the specified disease circumstance, only have to be a cause of element 1, the outcome, the authority, business closure. It would be open in theory to give it a meaning that element 3, the specified disease circumstance, requires to be the cause of element 1, the authority closure. And just looking at the words alone, that could be justified. But we know from the Supreme Court's analysis in FC and Arch that there may be situations in a disease context where that would be unfair because of the existence of other circumstances being involved in an outcome, such as disease being experienced further afield from the insured premises. It's not inevitable that there will be such a situation, and the policyholder wouldn't really have anything to make him worried about that or predict it from the wording, but that could happen. And to avoid unfairness, AXA accepts that it's right and fair interpretation of the causal phrase due to is that the specified disease circumstance only has to be a cause of the insured premises being closed down by authority and not the cause. But we say that having got to that stage, we say that it's important that first of all the specified disease circumstances are not messed about with and redefined. Because if you do that, you're changing the causal inquiry. And secondly, that the disease circumstances that are actually specified are in fact a cause of the business authority closure outcome. And it's right and fair to do that because it reflects the requirement of the agreed words and because the causal requirement is being given an expansive meaning, a cause rather than the cause or sole cause. Now, how is it to be determined whether the specified disease circumstances were even just a cause of the closure? We say the requirement isn't a demanding one. It is that the specified disease circumstances contributed to the outcome of the authority's decision to close the premises. How much of a contribution does there need to be? Not very much, we suggest. Possibly more than de minimis, but there's no requirement that it be a substantial contribution or a material contribution. It just needs to contribute. How does the required contribution need to contribute? The problem with many possible things being involved in producing outcomes is that it can be complex to see what's going on. So one can't be too demanding about it, especially in a policyholder context. Are there any features of the contribution that allows clarity as to whether there has been a contribution? Yes, we say. Where the outcome is a decision of a human agency or the product of a decision, what generally brings decisions about is information that comes to the agent's attention. That is true in the context of a human agency dealing with communicable disease. If that information existed prior to the agency's decision and is taken into account in reaching the decision, it contributed to the decision and it was a cause. The requirement for information to be taken into account as a causative aspect of the authority's closure decision comes in because it's inherent in the concept being used to address the possibility of concurrent causation in this context. It doesn't require extra words. It doesn't require the insured peril to stipulate that disease be manifest. Mr. Naylor will address you on what we say is the meaning of suffered. And we say our cases that suffered does mean manifested. But at this stage of the argument, we're neutral about that. The analysis applies whether it's occurrence wording or display manifestation wording.
Well, subject to the suffered and manifested point, why was information about the disease at your premises not taken into account by the government when they reacted in response to all the cases in the country? And one of the cases in the country, at least, was at your premises.
No, because what the government was, and I'll address this in more detail, but just shortly, what the government was responding to was reported cases. Reported cases were about 8,000 number. They came from hospitals. Each case, each person suffering had a postcode, and the case was attributed to a local authority administrative area. So you could map the cases in the country. I'll take you to a map showing that. The other aspect that the government was aware of was suspected cases in the country at large. Those weren't actual cases that people knew about. Those were suspected cases. They believed that there were more than 8,000 cases, possibly far more. But those were cases that were in the country at large, and they didn't have a territorial association. They weren't linked to business premises. They were a notional concern that there was more out there that they suspected existed. And the case of someone at the Mayfair nightclub who had COVID prior to the 20th of March wasn't part of that. That wasn't within the government's ken. It wasn't on the radar. And the reason it wasn't on the radar was because they had certain specific concerns that they had to address at that particular time. At that particular time, they were worried about a rising epidemic that became a pandemic that would overwhelm the NHS. They were concerned about the national effect, the demand being made on NHS resources. They weren't yet at the stage of looking at individual settings or individual places. Before this stage, i.e. just before the lockdown measures, and we're interested in the business closure measure, before that happened, there had been a looking at actual places and settings. It was part of the influenza protocol which had been in place already. And there was a protocol called the first few hundred, where the plan was you looked at individual cases and you did contact tracing. So that was a time when the government was interested in actual individual cases linked to individual places and the effect on other people. After the lockdown, there was concern about individual cases and settings. You may remember it was about July 2020 when they managed to scale up the testing. And at that stage, testing and tracing commenced. And at that point, there was focus by the government on what was happening at settings. We've seen, an example was made by Mr. Keeley, the Kirklees meat factory was closed down because certain employees, a cluster of cases was found in employees, they closed the factory down. There's a couple of factories in Wales. There were situations where that happened, but the short answer to my Lord's question is it's a different concept. The specific case at an individual place isn't covered either by the reported cases or the known unknown. And that's an element I want to go into a little bit of detail to show you the relevant evidence on.
But the closures, the lockdown, wasn't a closure of every space in the country. It was a closure of particular classes of premises.
Yeah.
And that was because of the risks associated with people with COVID being in those classes of premises, was it not?
Well, that's a conceivable risk. The thinking possibly was if these premises are closed, then people aren't coming out and going to other places. But I accept that.
So to that extent, the government plainly did have in mind premises specific known unknowns, didn't they?
No, it didn't have what this clause contemplates.
It wasn't specific by reference to one particular place, but it was specific to types of places which included late night bars.
I accept that the regulations on the 21st and 26th of March identified specific classes of business, and that included nightclubs. I do accept that. Of course I accept it. But my point is that the government may have taken measures that affected businesses, but what we will contend is that the evidence that's been disclosed in the Sage Minutes and the agreed evidence identifies known unknowns just as a general concept and isn't thinking about the situation in settings. For example, was there studies on the risk of exposure in nightclubs or risk of exposure in nail salon bars? The answer we say is no, because they're not at that stage concerned with settings. They're concerned with the totality.
But surely you don't need a study in relation to the risk of spreading of disease within locations such as nail bars and nightclubs, if you're the policyholder, and the government specifically targets those types of institution in the regulations. How can it be said that if the regulations specifically say we are going to close down all nightclubs, they don't have nightclubs in mind?
Well,
you say you've got to spell out that it happens to be the particular nightclub in Mayfair.
We say that the policy requires what happens in this club to inform the decision of the authority.
This particular club.
Yes, and that may...
So unless it can be shown that when the government promulgated the regulations, they had it in mind that a specific club in wherever it is, in Mayfair, might have cases of COVID-19, then the policyholder isn't covered. Is that the proposition?
Well, lady, we say that this policy doesn't cover prophylactic measures. It covers a case at these premises informing an agency's decision. And if that's not satisfied, then the policy isn't engaged.
So I think the answer to my question is yes, that is your case.
We say that it has to be taken into account, and it wasn't. That is our case.
So just to be absolutely clear, unless the government has a specific premises in mind when it decides to shut down all such premises, they're not covered.
We say that this particular response, an undiscriminating national closure, was not covered by the policy. Mm-hmm. If there had been individual targeting, that would be a different circumstance. Now, if it was the case that the specific place is within contemplation, taken into account, then it's covered.
Well, that's where I'm struggling, you see. I just want to be fair to you to understand your case. At the moment, I'm struggling with the idea that if all types of venue of a particular type are in contemplation, why it can't be said that the specific places of that type are not also within contemplation. And as I understand it, your answer to that is because you've actually got to look at this particular address. But if that's not your case, I'd like to know what it is.
The requirement of the policy is that the disease circumstances, namely a person who's an employee or visitor, has the disease. So the two requirements are location and the characteristics of the person that has it. And we say to engage those requirements as a cause, they need to be taken into account. And the reason that it's not been taken into account at this stage is because the government wasn't focusing on individual places that had it. They did other times, they did before, they did after.
I mean, this is a variation of submissions we've already heard about restaurants and rats and so forth, yes. But as I understand it, your case is that it would not be enough for the government to have information saying, we know there have been cases of COVID at some nightclubs, nightclubs A, B and C, so we better close down all the nightclubs. That's not good enough as far as you're concerned for this policy at this premises.
Yes, exactly.
And that's a summary of your case, isn't it?
Yeah.
Okay.
It would be good enough for A, B, or C where the data was coming from.
Yes.
Which, yeah,
but if you're the unlucky one who is not A, B, or C, then you're not covered.
And when you submitted that the closing agency must have information about a case at the premises is that it must therefore know of a case at the specific premises. Is that part of your submission?
So what we say is that the contribution is defined in terms of information that's taken into account. That's capable of covering a number of situations. It's going to depend on what kind of closure is going on. If an authority goes to an individual premises and discovers that one person has a disease because he's told about that, or they do testing, then that's going to be information which gives them knowledge about it.
I understand that, but do you say it's confined to knowledge?
No, we
Or
don't.
do you say it's sufficient, for example, if there's information which suggests that there might be a case at the premises?
No,
Is that sufficient?
no, we draw the line.
Where do you draw the line?
Well, we say that what the policy isn't contemplating is the possibility of disease, because there isn't a requirement of possible disease of the circumstance, or the disease may have been suffered. It is clear about the fact that there requires to be a disease. So we don't accept that it would be covering a possibility.
Right.
We do accept that knowledge will come into this, and we accept that reasonable belief is sufficient.
Even if mistaken?
Not if even mistaken.
No, because if it was mistaken, there wouldn't be an outbreak of disease at the premises, so you wouldn't get cover for the actual peril. But I'm struggling to find why a reasonable belief isn't a contemplation of a possibility.
Contemplation of a possibility appears a much broader concept. Reasonable belief would have to be informed by specific circumstances. And we say that some help is going to be provided to the policyholder by the context in which the closing down takes place. So if it's been closed down as part of a statutory context, prohibition notice, then that will identify the circumstances which the inspector has found. That is providing the basis for a reasonable belief.
So if the inspector goes to your premises and sees all the sweating bodies on the dance floor in close proximity to each other, and decides to close the place down, and there is in fact some of them have got COVID there, is that enough?
Yes.
Or does it depend on whether he thinks, well, there is probably COVID here already, or he only thinks looks pretty dangerous?
He's getting information. He's taken it into account. He's concluded that his belief is it was COVID, and he closes the premises. We would say it was covered.
So he has to conclude. He has to form a belief that there is COVID there already, not that there might be very soon if he doesn't do anything.
Yes, because
That's the
prophylactic
stage. Yeah.
is not covered.
Yeah, I see.
If the numbers of known unknowns were, let us say, 1 million, that would mean that the government thought that 1 in 70 people, roughly, had COVID. Now, if the footfall in your nightclub was more than 70, why would that not involve a reasonable belief that there had been a case of COVID at your nightclub?
The reason that wouldn't be sufficient is because known unknowns, whatever the number, is a belief about suspected cases in the country at large. It's not being identified with a place or an area. And this policy wording is specific in addressing disease in a place. That's the reason.
They've got to have had your particular premises in their minds.
Yes, and I mean, so if that could be a real possibility. So I mean, what could have happened is government saying we think nightclubs, and asking nightclubs to respond as to whether there's been any cases. And that information comes and informed a decision. That would have been a possible way to get data. But it just so happens that on this broad approach that was taken to close down, that wasn't taken, and that's not what the policy is addressing.
Thank you.
Now, the contest in this case just explains our interpretation, namely that a causal requirement, which is that it is a cause, and we accept that that shouldn't be applied unfairly. One needs to take account of the fact that large numbers might be involved, and so that should be taken on board. The policyholder's position at the outset of the proceedings relating to the preliminary issues was based on paragraph 212 of the Supreme Court judgment. And that's at Authorities Bundle 188. Tab 2. And as long as there had been a single occurrence of COVID at the territory specified in the policy, in FCA Arch it was obviously radial areas of 1 mile and 25 miles. As long as there was a single occurrence prior to the government closure, that was causative. It combined with all the other cases outside of the area. Now that included a case at premises nobody knew about prior to the 21st of March, when nightclubs were required to close. For example, an asymptomatic case. And that's why the first issue in all of these cases was whether the presence of one case at the premises prior to the government action was sufficient. We say that a case like that is not a cause of the national closure. The government didn't have information about it that it could take into account in deciding on national closure. So it wasn't a contributing factor in the government's decision because it was unknown about at the time of the decision. And so it wasn't the subject of information taken into account. It wouldn't be on a list. There wouldn't be an official low down the chain that was aware that it had been factored in. And the fact that a case is later confirmed at the premises, which might be some time later using statistical evidence, it doesn't alter the position. A thing that comes after the decision isn't a cause of the decision.
Well, paragraph 212, which you've referred us to, contains 3 sentences. The first and the third, beginning "we conclude" and "our conclusion," are points about the interpretation of the policies before them in that case.
Yeah.
And you can fairly say that those are radius clauses and not at the premises clauses, and that and that such clauses are, or at least may be, different. But the middle sentence, the basis for this conclusion, is simply agreement with the divisional court's finding of fact, isn't it?
It is.
And that finding of fact is that each of the individual cases of illness which had occurred by the date of government action was a separate and equally effective cause of the action which was taken. And how can you say in those circumstances that the case of COVID, which occurred at the Mayfair nightclub, was not a separate and equally effective cause of the government action?
Because we say that on a...
You have to disagree with the Divisional Court and Supreme Court's finding of fact, don't you?
No, wouldn't dream of being so impertinent. What we say is that on a proper interpretation, what is being talked about is the cases as to which the government had information. And the cases as to which the government had information were the reported cases that were attributed to administrative areas around the country and to known unknowns. Known unknowns didn't have a territorial association, so they were neither attributed to premises nor to radial areas.
So the second sentence should say, each of the individual cases of illness resulting from COVID-19 which had been reported rather than had occurred.
It should be a reference to reported cases.
But it isn't.
Well, the reference back, so this is a concluding paragraph, and it obviously needs to be read in the context of what's come before it. If we look at paragraph 176, if we go back to that, it's page 177. Your Lordship's mentioned about the reference to divisional court. As the court below, so halfway down, paragraph 176, as the court below found, the government measures were taken in response to information about all the cases of COVID in the country as a whole. And the information that the government had was the reported cases allocated nationally according to local administrative areas, and the suspicion that there were more cases than that. And we say that information is properly construed as referring to the information that they had about cases.
Reported and suspected. I thought your
Yeah,
case was,
yes, but
it was only reported.
But the suspected cases weren't relevant because they're not cases that are being allocated to a particular area. And that's what the Supreme Court was concerned about. It was interpreting clauses that related to a 1 mile and 25 mile area, and the requirement was that there be a case in those radial areas. That was the subject of what was being addressed. Now, 176, we say, is significant because it's referring to information and response. So there needs to be information and it's respond. At paragraph 179, so halfway down at letter D, as already mentioned, the court below found as a fact at paragraph 112 of the judgment that the government response was a reaction to information about all the cases of COVID in the country. So talking about a reaction to information. Paragraphs 182 to 185, that pages. So 182 to 185, I won't go through it in detail, but that is where the Supreme Court assesses the matter in terms of contribution, and we say is adopting a contribution approach to causation. And if we go to the end of 185, page 180, it says in all of these cases, it's talking about a number of examples, including number of people contributing to push a bus over the edge. In addressing those examples, it says in all these cases, each individual contribution is reasonably capable of being regarded as a cause of the harm that occurs. So that's where the contribution concept is being endorsed. And bearing in mind what I pointed to in terms of 176 and 179 about the factual findings of the information government was responding to. If we then follow it through and go to paragraphs 206 to 207, it's at page 186. By contrast, an interpretation that recognises the causal requirements of the policy wordings as being satisfied in circumstances where each case of disease, pausing there, we say that each case of disease by reference to the policy wordings is the case of disease in the radial area. And that, we say, is confirmed when one reads paragraph 207. So each case of disease informs, so again, this idea of informing a decision to impose restrictions and treats, we would underline the word treats each such case as a separate and equally effective cause of the restrictions, irrespective of its geographical location and the locations of other cases. And we say what that is referring to is ruling out the but-for test. That you don't focus on the location of each case and then set them off against one another. But that properly understood, what this paragraph is saying, that when it comes to construing these policy wordings, a case of the disease at the relevant radial area requires to be a contribution, requires to inform the decision. And at 207, just to make good what I was saying, this interpretation of the policies arrives at a broadly similar result to that reached by the court below, but by different routes. The court below interpreted the disease clauses as covering the effects of each case of disease wherever in the country it occurs, provided that at least one case occurs within the radius specified in the clause. An interpretation that we think makes best sense. Only the effects of any case occurring within the radius are covered, but those effects include the effects on the business of restrictions imposed in response to multiple cases of disease, any one or more of which occurs within the radius. And I think I should take you to Divisional Courts 112, which was being referenced to, which is at tab 1 at page 29. Paragraph 112. probably, if your lordships were to read that.
So it refers to reaction to information about all the cases in the country. The information which the government had was not only the number of reported cases, but the information that there were more cases than those which had been reported.
But for the purposes of the exercise that was being undertaken by the Divisional Court and the Supreme Court, what they were interested in was cases in a wide area that corresponded with the 1 mile and the 25-mile areas. Now, government's obviously not responding to what happens in an actual insurance policy defined area. When a communicable disease problem is being dealt with, they're not interested in the insurance constructs and private agreements. But what they are interested in are areas that correspond with that. And we say that what corresponds with that were the administrative areas, the LTLAs, the lower tier local authorities, where cases were being allocated to that. And we say that the case that the FCA ran was to put before the Divisional Court and Supreme Courts maps which depicted the 25-mile cases, radial cases, and also maps showing the LTLAs. And the FCA's case, we say, was to equate the two. So effectively, what was happening in the administrative areas was standing in place for what had been happening in these notional wide areas. Because focus on the wide area, focus on the radial policy provisions. If that's what you're doing, saying we're only going to cover you if you can point to the government taking into account what's happened in the radial area, then there would be no useful cover, because authorities aren't working on that basis. And so it is being understood that instead of the insurance radial areas, what is being talked about is government response in terms of knowing about cases in local authority areas. And I'll show you the maps in a moment. What we say is significant about paragraph 112 is that it referred to the agreed facts, and I'll be taking your lordships to the agreed facts because we say it's important to know what the agreed facts were in FCA against Arch, where there was a passing reference to known unknowns. There was reference to modelling but not agreed, and then there was extensive reference to reported cases that were allocated to local authority areas. It had been done in spreadsheets, and the country was, and the government was thinking in terms of cases in wide areas across the country. So that's and they refer to Mr. Edelman's submissions about that, and we say that his submissions were to that effect. And they refer finally to Mr. Hancock, who talks about it being decided that we're in this together, and the shape of the curve has been similar across the whole country. And what was being referred to was the curve in terms of hospital admissions across the country, which was the source of data for reported cases, which could then be allocated to areas around the country. So we say that there is a proper construction of all the cases in the country, but it's not referring to every conceivable case. And the reason it's not talking about that is because the paragraphs in terms talk about information and response. It's not a notional idea of anywhere in the country where it may or may not be. it's specifically talking about information, and there was information and data which informed that. And we say that that actually provides integrity to the Supreme Court's judgments, because if it is the case that the Supreme Court in paragraph 212 was really saying that a case that happened anywhere that nobody could ever possibly know about because it was asymptomatic was a cause of the government's decision, then that effectively would be a conclusion that there was no causal requirement, because such a case cannot be a cause. We say what provides causal integrity to the Supreme Court's conclusion was that there was a something else, and this something else was the information which the government had about reported cases that were allocated across the country. And because of that basis, it was able to conclude that cases in radial areas were the cause.
But it didn't only have information about reported cases, and it didn't only take into account information about reported cases. It also involved a good deal of modelling about how serious the situation was by reference to cases that weren't yet reported from the very limited testing.
Well, we say in relation to modelling that one has to be careful about that. I'll take you to the agreed facts, where modelling wasn't accepted. There was a lot of modelling done. There was a lot of modelling done for different purposes. There's actually a big difference between modelling, i.e. you put in data, and then you have certain suppositions or premises which then produce information. What we say is that when one looks at the Sage Minutes, and fortunately there aren't that many references, but I'll show you the ones that are relevant. What the modelling that was relevant to the exercise of possible cases in the country was saying was that there were 5,000 to 10,000 cases possibly as at the 11th of March. By the time it got to the 16th of March, there had been a data lag, because it takes time for people's conditions to feed through and then being put through to the modellers. The information then came and they revised that assessment of 5,000 to 10,000 cases nationally to 5,000 to 10,000 cases daily. So as at the 16th of March, that's what they were thinking was the possible problem in the country at large that they didn't have data about. And on the 20th of March, they make the decision to close the businesses. So in response to the observation that Lord Justice Popplewell made in respect of the millions of cases, we say that that's not actually the evidence. The agreed evidence certainly doesn't say that. And the Sage Minutes are actually talking in number of tens of thousands. And we say it's significant that the Supreme Court majority judgment was careful in its characterisation of the extent of the number of cases, i.e. reported, and others, in saying that it was thousands of cases. And we get that from paragraph 69 at page 153. And at letter B, on any reasonable or realistic view, those cases comprise thousands of separate occurrences of COVID-19. And we contrast that with the reference, I think you've already been taken to, where Lord Briggs talks about 1 million cases or approaching 1 million cases. We say that is possibly a literary flourish to emphasise the point he's making, about the approach being taken by the Supreme Court responding to multiple causes. But the actual agreed evidence and the Sage Minutes are talking about cases in the region of tens of thousands. And why that's relevant is because it scotches the idea that it was everywhere in the country prior to the 20th of March when the business closure decisions were being taken. It wasn't literally, that's being used as a figure of speech. It wasn't at every home or nightclub or nail salon or coffee shop. They didn't know exactly the number. They didn't know exactly where. When one talks about known unknowns, the unknown element are the numbers and the locations. And we say that it's, and I think in the Brian Layton case, my Lord Justice Popplewell, it's at AB 341077, and characterising what FCA and Arch had found, talked of every case approaching or even exceeding 1 million in number. The true number of cases wasn't an issue in that case. So that's a reference that's being made.
That was a reference to Lord Briggs's.
Precisely. But actually, we don't accept that we're in that territory. And what I'm going to try and eschew going into too much detail. I do want to keep my submissions at a high level, but I do want to show you some material we say is relevant to this. The FCA in the Divisional Court and the Supreme Court relied on maps. One map was a map of the 25-mile policy area, and we see that in Supplemental Bundle Divider 22 at 107. So that's England being broken down into notional 25-mile areas. There wasn't a corresponding map for the 1-mile position, and that's something that the judge made reference to in the judgment, because I made the submission to him, and he said, well, there's no 1-mile maps. It doesn't matter. It would be a forensically more difficult exercise to do 1-mile breakdown. But the same reasoning applies because neither the FCA or any of the courts differentiated the position in principle of 1 mile and 25 mile. And so the reasoning applies. The other maps that the FC relied on was lower tier local authority maps. And that can be seen at Supplemental Bundle 23 at pages 108 to 109. And 108, it describes what it's about to show, colour shading, showing LTAs, which had the first reported cases by 4 dates, 2nd, 9th, 16th and 23rd of March. The agreed facts set out that there are 317 lower tier local authorities. The reported cases are available on the UK government website. And by sorting column A in the spreadsheet into the different LTAs, it's possible to see how many individual tested positive cases on each day and cumulatively for that LTA reported cases. And then moving down, sorry, next page. So those were the four maps. So the breakdown is of lower tier local authorities. It's been coloured in if there is a case that has been reported and allocated to that administrative area. So the postcode of the patient is found and then that's mapped onto the administrative area. If we look at the fourth map at the bottom and enlarge that, so it's the lower right-hand side. This was the map showing lower tier local authorities had their first reported case up to and including the 23rd of March. And every LTLA in the country, with one exception, North Devon, on the bottom left, had a case. It's sometimes said that the Scilly Isles didn't have a case. Scilly Isles actually did have cases. It's just that they had less than 5. And so for reporting purposes, they were dealt with along with Cornwall. So there was one case. So for all intents and purposes, the country was affected in the terms that each area had been designated with cases. But it wasn't a case of them being everywhere. This wasn't the basis of the information that was being known about, that was being mapped onto wide areas. And we say that that's correspondence between the wide area approach and the information that was actually available to government shows that what the information that was being referred to in the divisional court and adopted by the Supreme Court were reported cases when the whole purpose of the exercise is to consider what has been caused by a case in a radial area. And if I can take you to supplemental bundle 24.112. If the top right could be blown up. This was Mr. Edelman's submissions in reply to the divisional court.
Sorry, where are you? Tab 24?
Page 112. That's a transcript with 4 pages on it.
I don't seem to have that. I go straight from 109.12 to 115.1. Anyway, read it out and I'll pick it up later.
So it's on the screen.
Yes, I don't have the screen.
Oh.
But you read it out.
Yeah. So line 14, helpful to show you a document we've added to the bundle based on all the information. It's just a piece of forensic work and he gives a reference. And that's referring to the lower tier local authority map. This is drawn from the government statistics, all in the agreed facts. There's none of this that's taken others than from the agreed facts. This is all just dealing with reported cases. So it's not the controversial bit about projections.
Yes, I found it actually. In my bundle, it's page 115.3. Don't know what's happened there, but anyway, I've got the right passage, thank you.
And Sorry, my lord, my eyesight isn't able to deal with A5. Is it? You can go to page 115226. If we could blow that up, please. And if we could scroll down, please.
Which of the smaller pages are we on? 97, 98? What are we supposed to be looking at?
Oh, Lord, I'm just sorry, I don't have the reference. My Lord, I think we may be close to the 5-minute break for Opus. Would it be convenient to have a 5-minute break?
Yes, all right, we'll do that now.
Yeah.
You don't need to go on it constantly.
Yes.
Lord, grateful. If you could have supplemental bundle 115.27. If you could go to page 124, the bottom right hand corner. This is Mr. Edelman at line 12. He's addressing the issue of manifesting and what it means. And 17, he says, we just simply submit that it requires to be diagnosable. But seeing as we're dealing with government response to the information that it had as to actual and anticipated apprehended cases in the sense of reported and then known and unknown cases, this may not be a matter of particular significance. So they're referring to known unknowns in the context of manifestation. But if we read on, it says, Mr. Turner also said that the lockdown is not in any way causative because he said it was preventative or anticipatory in nature. But for the reasons we have, going over the page 125, given the lockdown was, we say, precipitated by the manifestation of the disease, i.e. actual occurrences and the high number in the relevant policy area, and in all the relevant policy areas where the map that was showed to you and the spreadsheet showed the disease to be present and apprehended. And so what the FC was doing was equating those two maps that I took you to say that effectively those should be read together. And that essentially is the point that I'm seeking to make, and that was actually the database that informed the Divisional Court and the Supreme Court in terms of about information that was being responded to. And in terms of the high R number, our numbers logically are based on reported cases. You want to know the rate of infection. It's based on information that you have, not about the suspicion of there being more cases out there that you don't know about. So the R number reference doesn't dilute the point. Can I take you to the agreed facts in the Supreme Court? And we get those. It's supplemental bundle tab 70.
70.
70, my lord, yes. Now, the agreed facts start at page 790, and the text of it goes through to page 807. Time precludes me from taking you through it, but I would invite the court, if it has an opportunity, to read this document, because we say that it discloses the relevance of actual reported cases being the information basis. In terms of the known unknowns that are being dealt with, we see a reference to that at page 805. And it's at paragraph 41. The actual presence of COVID in the UK in March would have been much higher than is reflected by the number of reported cases. However, the extent of the difference between the number of reported cases and the actual number of people infected with COVID-19 is not agreed. That is the extent of the agreed evidence on the known unknown cases. It would have been much higher. Turning to 3 Sage entries, supplemental bundle tab 2, page 4. This is Sage Minute 14, number 14 on the 10th of March. Paragraph 5, if we could have that brought up. Situation update. So this is the 10th of March, just to get our chronological bearings. 10th of March, closure decision on the 20th, brought into effect on the 21st. Based on surveillance, i.e. we would say what you know about data, including cases in intensive care units for whom there's no travel history accounting for infection. The UK likely has thousands of cases, as many as 5 to 10,000, which are geographically spread nationally. Making good the point that I say that this is, that's the only association in the country at large. Then looking at Sage Minutes for the 13th of March, at Supplemental Bundle tab 4, page 13. Item 1, owing to a 5 to 7 day lag in data provision for modelling, Sage now believes there are more cases in the UK than Sage previously expected at this point. We may therefore be further ahead on the epidemic curve, but the UK remains on broadly the same epidemic trajectory in time to peak. And then 3 days later, Sage Minute 16 on the 16th of March, that's Supplemental Bundle, tab 5, page 18. Paragraph 7. It's possible that there are 5 to 10,000 cases, new cases per day in the UK. Great uncertainty around this estimate. And this is in the context of minutes that are providing data on actual cases. So data has been provided about actual cases, and the information that's been provided about known unknowns is limited to that. And the entry for the 13th of March, Sage Minutes 15 at Supplemental Bundle 413, the significance of that for modelling, it's to make good the proposition. It says the lag in data provision for modelling. Modelling is being used, but what it's generating on this issue are numbers in the tens of thousands. The modelling isn't producing numbers indicating that we've got 1 million cases or millions of cases.
You've just shown us a page which said on its face that the numbers were now in the region of 5 to 10,000 a day and were doubling. That just can't possibly be right, what you just said.
Milady,
It's a matter of basic maths.
Milady, all I'm able to do is to identify the evidence.
Quite, but I mean, you've got to identify it accurately.
Well, I read it out. I don't think I've gone beyond stating what's stated in the Sage minutes themselves.
No, I think I was just taking issue with your proposition that it couldn't be in the millions when there was a page which said that it could, if you actually carried it through to its logical conclusion.
Well, doubling every 5 to 6 days, is it?
Yeah.
So the business decision is taken on the 20th of March. And what we say is that the reasons that known unknowns aren't equivalent to cases at premises is because known unknowns were suspected across the country and weren't being allocated to business premises or specific places. It was a concept that didn't have territorial association. Known unknowns wouldn't tell you anything about whether particular premises were affected. We note that neither the Divisional Court nor the Supreme Court relied on known unknowns. I mean, what the policyholder are doing in this case is not relying on the agreed facts from the Supreme Court, but saying on the known unknowns. The Supreme Court didn't emphasise the existence of known unknowns. If that had been a predominant feature of its analysis, one might have expected that was being highlighted.
I can see that this submission might go to the question whether a policyholder is able to prove the occurrence of an insured peril. That is to say, if there was only a relatively low number of cases in the country, tens of thousands, then they may find it harder to prove that one of those tens of thousands was at a nightclub or a nail bar or whatever it may be. But I don't see really that this goes to the question whether the government acted in response to all the cases in the country, both known and unknown.
Well,
which is the causation point.
We say that the material that I've taken you to does support that. The reaction is actually to reported cases being allocated across the country according to lower tier local authority areas.
Well, it may show that Lord Briggs was wrong to speak of 1 million, if that's not what the evidence actually justified, although you'd have to do the maths, and Lady Justice Andrews is better at that than I am. At least I can't do that in my head. But it still doesn't affect the fact, does it, that whatever the number was, the government knew that there were more cases than it had seen reported, and acted in response to that.
Well, I've made my submission, my lord.
Okay. All right. Well, we'll consider it.
The significance of the any visitor or employee wording. The judge dealt with this at 360 of his judgment at Core Bundle at D 28461. And he held that there was no significance in terms of the causation analysis, the fact that it required to be a person that was a visitor or employee and he applied the same causation approach that had been used in the other at the premises cases, which concerned persons rather than employees or visitors. And we say that the effect of that was to read out the words employees or visitors.
Who would qualify as someone at the premises who was not a visitor or employee at a nightclub?
An owner of the company who was a natural person, so a sole trader, would be covered by somebody who was an employee or visitor. We'd say that a partner would be covered. If you're running a business and you're there every day, you're not a visitor. You never describe yourself as such or be characterised as such. There are classes of persons who are not employees and not visitors.
But not in your case.
So,
Sorry, not in the Mayfair case.
so the Mayfair case we accept was a corporate entity, and we say that a director of a company that didn't have an employment contract wouldn't be normally characterised.
Well, he'd be a visitor unless he was there all the time running the place, wouldn't he?
Well, but that does happen. I mean, people, they're the face of the company and they're running the place. It would be artificial to characterise them as a visitor. Now, the judge thought...
But was the judge right to say it's like to cover practically all the people who will be in the premises?
No. So that's a factual point. But factually, it's not right. The scenario the judge has in mind is a club that's full at 2 o'clock on a Saturday evening. Or at 10 o'clock on a Monday morning, when an owner is in doing his VAT, he might be the only person in the premises.
That's not the relevant question. The relevant question is who has been there who might have had a human notifiable infectious disease over the period that the disease was prevalent.
Well, quite.
That's over the whole period. So the fact that the one director was there in the morning doing the VAT returns on his own is to be compared with all the people who have been through the nightclub at the time in the weeks leading up to the lockdown who might have had COVID. It's practically all people, isn't it, who are visitors and employees?
Well, we say that we accept that at particular times it would be, but we think that it's significant that an important person in the running of the business wouldn't feature in this description. And it's it's natural words, visitor, employee, and essentially what the judge is engaged in correcting by mistake, just to read the words out so that effectively he's reading it as persons, because he's concluding that it falls into the same category as all the other policies, which are simply persons. And we say that that's not justified because it has meaning, and it has meaning against the health and safety at work provisions in particular. And if I can take
I suppose depending on how the policyholder organises its business, there might be some categories of people who are not employees. If, for example, they outsource to an independent contractor, catering or security or cleaning or something like that. But what does this go to? Because suppose the evidence was that the only person who'd suffered COVID at the club was a cleaner, and that cleaner was not an employee because they used an independent contractor. Well, that would just mean they hadn't engaged the peril, if that's the right interpretation of the peril. But are we concerned with that factual issue now?
We're not concerned with that.
We're just concerned with the causation question.
It goes to two things. First of all, when you look at this policy, is it something that brings to mind of the ordinary policyholder a national response? And we say it doesn't, because the inclusion of the visitor employee aspect is anchoring it to the premises and conveying that this is a premises situation that's being addressed. So it's relevant from that point. And it's relevant for the second point, that if your lordships accept the submission that an authority has to be responding to the disease circumstances. The closure was made in relation to persons generally without discrimination as to what kind of persons or categories that had a relationship with the premises. They weren't thinking in terms of employees or visitors. Their thinking was more undiscriminating. And
So have I got this, that the relevance of this visitor and employee point is that the question is whether that language brings to mind a national response when we are looking at the clause as a matter of construction to see what kind of causal link it requires.
Yes.
That's the point, is it?
Yes.
And therefore your submission is that because visitors and employees is narrower than everybody, we should be looking at not necessarily a national response satisfying the causal link required by this clause.
Yes.
That's essentially it?
that's the submission.
Okay, that's helpful for me to know. Thank you.
Lord, unless I can assist you on the causation, I'll pass over to Mr. Naylor to deal with Stafford briefly.
Yes, very good. Mr. Naylor?
My Lords, my Lady, my submissions will address ground 1 of AXA's appeal, which concerns the proper construction of the phrase suffered by any visitor or employee in the Mayfair disease clause. My submissions will be limited to 15 minutes, but full details of AXA's case on this point of construction are set out in paragraphs 7 to 17 of our skeleton argument. In short, my Lords, my Lady, on this ground of appeal, AXA contends that the learned judge was wrong to find, as he did in answering preliminary issue 13, that the word suffered, as it appears in the Mayfair disease clause, was to be equated with occurred or sustained. We say that the judge should properly have held that the Mayfair disease clause is a manifestation type wording. That is, the insured is required to prove that a person exhibited symptoms of and or was diagnosed as having the disease at the time when they were on the premises, as opposed to merely having contracted the disease at that time. Now, there are a number of factors which we say require such a manifestation construction, but where the judge fell into error, we say, is essentially by treating the word suffered in the abstract and not giving adequate weight to two important contexts. First, that the word suffered is used in the context of disease, and so we are concerned with the ordinary meaning of that word in that particular context. And second, that the Mayfair disease clause does not just require disease to be suffered at the premises, or indeed suffered by any person at the premises, but rather it requires the disease to have been suffered by a member of just two specific categories of persons, namely visitors and employees. Now, AXA contends that the only way, and certainly the only commercially pragmatic way, that either the insured or the insurer can point to cover being triggered by one of these particular categories of persons having suffered a disease at the premises is where the disease in question has been manifested in or by such a person. Now, as to
manifested at the premises? No, because you say diagnosed will do.
My Lord, it will be a question of fact in any particular
Yeah,
circumstance.
but do you mean manifested at the premises? Because I thought you included in your categories of those who were covered, those who were exhibiting symptoms and those who had been diagnosed as a separate category. Now, those who have been diagnosed might not be exhibiting symptoms.
Indeed, my Lord, and the reason I say it will be a question of fact, because if in the particular factual circumstances a visitor or an employee had been at the premises and had then gone to get tested immediately thereafter, it will be a factual question as to whether, obviously, they then would have manifested the disease because it would have been tested and reported, yes, they've got COVID.
But not manifested to anyone at the premises?
Not to anyone at the premises, no. But it
So
would
it's
be,
manifested to anyone, you say?
indeed, manifested to the sufferer themselves, so in the form of a headache or a runny nose or a loss of taste,
Yes.
or manifested to a tester. In other words, it
Or
has to be-
manifested to them, to their family at home?
Well, potentially, but it's a question of proof, and we say that that is what turns this wording from, or it's one factor, which turns this wording from, or means that it is a manifestation and not an occurrence wording. And we'll
If it's a manifestation clause, why doesn't it say manifested or shown symptoms of? It says suffered, and as a matter of ordinary English, if you're suffering from flu, you're suffering from flu, whether or not somebody else diagnoses it.
Like the tree falling in the forest.
Well, my lord, respectfully, we would say that the clause has used a language of manifesting, and I would say that in ordinary everyday language, it would be more common to talk about someone suffering from flu than to say they have manifested flu. Manifestation is certainly a wording that's used in the disease clause, as we see that in the test case. Suffered is the more common everyday language. And your lords, your ladyship may notice I've got something in my throat at the moment. I fell ill on Friday last week. I suspect it was already in my system on Thursday. But had you asked me, are you suffering from anything, or are you suffering from a cold, because it might be a different question, I would have said no on Thursday. I would have said yes on Friday when I started sneezing and exhibiting symptoms. And of course, it's different where if someone had tested me and got a positive result, then I would have known that I'm suffering from something.
If we asked you today, were you suffering from a cold on Thursday, you'd probably say yes.
I certainly wouldn't at the time, and that's the critical question for these purposes, my lord. I should say a word briefly about where this ground of appeal sits within AXA's appeal generally. Mr. Davey touched on this earlier. This point of construction is distinct from the causation issues which Mr. Davey has been addressing you on, but it's fair to say that it may have a bearing on causation insofar as a manifestation construction would provide further support to AXA's causation arguments concerning information. But to be absolutely clear, that causation analysis does not depend on a manifestation interpretation of the word suffered. Now, moving on, my lords and my ladies, to where AXA says the judge went wrong on this issue, we can see Mr. Justice Jacobs' conclusion at paragraph 358 of the judgment. This is in Core Bundle tab 28, page 460. In paragraph 358, the judge says, I accept Mayfair's primary case as to the meaning of suffer as being equated with occur or sustain. If I had not accepted that case, I would have accepted Mayfair's alternative case that suffer would include all of those in whom the disease was manifested in accordance with the approach in Declaration 7. If a visitor or employee was at the premises and either displayed symptoms of COVID-19 there or was diagnosed with COVID-19, then in both cases the disease was suffered by the individual whilst at the premises. I can see no good reason why the use of the word suffer should be interpreted more narrowly than manifest in the present context. Now, AXA says, to be clear, my lords, that the judge's primary conclusion was wrong, but contends that his alternative formulation was correct. That is, the wording used in the Mayfair clause should have been construed to have the same meaning as the manifestation wordings in the FCA test case, which I'll turn up in a moment. But before I do that, I would like to show you how the judge reached his conclusion, his primary conclusion. And if we could go back a couple of pages to page 458, paragraph 352, the judge said, it is unquestionably a common usage of the word suffer to mean that a person is undergoing a degree, including a very considerable degree, of discomfort as a result of disease or injury. And of course that is AXA's case about the ordinary, everyday, common meaning of suffering from a disease. Now, however, the judge said that that was not its only meaning, and he then set out below that paragraph a number of dictionary definitions of the word suffer. Now, many of these definitions, your lords and ladies will see, indeed, arguably all but one of them are supportive of AXA's position as to the meaning of the word suffered. That is, if we take the first definition, for example, to have something painful, distressing, or injurious inflicted or imposed upon one, to submit to with pain, distress, or grief. And in my submission, the only one which is significantly different in this respect is the last one over the page, definition 10, which brings in the word sustain, to sustain injury, damage, or loss. And this led the judge, in paragraph 353 of his judgment, to say that the word suffer may be used synonymously with sustain. And then he cited an extract from the Divisional Court judgment. and I invite your Lordship to read that closely, because what's actually happening in that extract is my Lord Justice Flo is dealing with a submission by Mr. Turner for the RSA that the word sustained required diagnosis, as opposed to an undiagnosed case, but it could be symptomatic or unsymptomatic. Now, I should say that we would accept as correct the judge's conclusion in the abstract. That is, the word suffer may be used as a synonym for sustain, depending, of course, on the context. But we contend, as I've already said in answer to my Lady Justice Andrews' question, that this is not the normal everyday meaning where disease is concerned. And we say further that it's certainly not the meaning where the particular context of the Mayfair disease clause is concerned, with its requirement that disease be suffered by a visitor or employee. Now, as to the normal everyday meaning of suffering from a disease, I have already just shown your Lordships and your Ladyship the dictionary definitions. Now, we say that the leading definitions there all accord with AXA's analysis that suffering implies a subjective experience, an unwelcome experience, something which, and not something which is not apparent to anyone, including the sufferer themselves.
You can be suffering from cancer without it ever being diagnosed.
Well, my lady, this raises a question of how that would ever, however, be proved, because you have to know, it has to become manifest in some sense before you can say someone is suffering from cancer.
Well, that's true, but somebody may diagnose it many years down the line, and then, as a result of testing, realise that the growth has been there for months on end, and they're suffering from cancer 6 months earlier, but it wasn't known to anybody until the diagnosis.
Well, my lady, that's why I say that we accept that there are circumstances in which you can read suffer as being sustained, but we are, of course, talking about a commercial insurance policy, and this is an element in an insured peril, where someone will be expected to make a claim. And so we say that there has to be some awareness there, that someone knows that something is happening, so that, I mean, we say for reasons of proof, but even to write to your insurer saying, I've got this circumstance, I want to make a claim. And
We
so,
seem to have got to a position where both meanings are linguistically possible. And I think you accept that, even though you say that there were a 9-1 vote in your favour in the dictionary, but nevertheless there is the one. The judge's reasoning for choosing what he thought rather than what you submitted seems to be in paragraphs 356 and 357. So is he wrong in regarding those as the criteria and in the conclusion he drew from them?
Indeed, my lord. In 356, he is talking about there being an uncertain threshold for what qualifies as suffering. And we don't take issue. Again, it's going to be a matter of proof in any particular case, but there has to be something. There has to be an outward manifestation, even if it's just a minor headache, which then crosses the threshold into symptoms, which we're then aware of. And I think that deals with the judge's point, certainly in 356. And as for the point about being diagnosed afterwards, I think my Lord Justice Popplewell's already asked me about that. As long as it's manifested, it wouldn't matter if there'd been a slight time lag, and that would be a question of proof in any given case. But my lords, I would like to show you, I've referred to what the divisional court said, but if I could ask you to look at the declarations made by the Supreme Court. This is at Authorities Bundle, tab 3, page 224. So my first point on the everyday meaning of suffering is we've seen the 9-1 definitions in my favour. If we could look at Declaration 6, which is on page 224. So this is a declaration that was first made by the Divisional Court and then reasserted by the Supreme Court. Subject to paragraph 7a below, there was illness sustained by any person resulting from COVID-19 within a radius of 25 miles, when any such person was infected with and or was suffering from COVID-19, whether or not they were diagnosed with COVID-19. And what I say the Supreme Court is doing in that declaration, crafted, one assumes, originally by a diligent team of counsel and then reviewed and approved by the Divisional Court and then by the Supreme Court, is drawing what I say is a distinction between 1, being infected with COVID-19, 2, suffering from COVID-19, and then 3, being diagnosed with COVID-19.
Were there any policies in the test case which referred to suffering?
No, my lord. I say that very confidently. It would have been brought to my
I'm
attention
sure
if
it
there were.
would, yes.
And you can see also, of course, that Declaration 7 there, my lords, I said I would turn this up. Declaration 7 is what we say, that's the correct test for the Mayfair disease clause. Now, it's a very short point, my lords, my lady, but the Mayfair policy itself actually used the word sustained in other places. And we set this out in our skeleton at paragraph 16. And so it's a short point, but we say that if it meant sustained, it would have said that for the next clause as well. But returning to the judgment below, my lords and lady, the judge held at paragraph 355, it's on page 460 of the core bundle, that in his view, and this was what was the deciding factor, it would seem, for the judge, in his view, it makes far more commercial sense to interpret suffered as it appears in the Mayfair policy as being synonymous with sustained, because in his view, this gives a clear and simple test to apply. Now, AXA contends that the judge was wrong to hold that it makes more commercial sense for suffered to mean sustained than for it to mean manifested. And indeed, AXA goes further and submits that the correct position is actually to the contrary. And it makes more commercial sense in the context of a policy sold to small and medium-sized nightclub businesses for the policy to use a manifestation wording, which is simple and easy for both insured and insurer to apply. Now, what I mean by that is that with a manifestation requirement, both parties are clear as to what the insured has to show, namely symptoms or a diagnosis of a disease in a visitor or employee. There's no question of engaging in an ex post facto statistical analysis or similar. A manifestation wording is in that respect quick, neat, and simple to understand and apply. You either have evidence of symptoms or a diagnosis, or you don't. If so, there's an insured peril. If not, there isn't an insured peril. My lords, my final point is keeping this sense of commercial pragmatism in mind. There is a key reason why the Mayfair disease clause is properly construed as a manifestation and not an occurrence wording. And this is that the Mayfair clause requires the disease to be suffered, not just by any person, but rather by two particular categories of persons, namely visitor or employee. And I say particular categories, but we could say it's persons with particular characteristics. They fulfill the function and role of a visitor or employee. Now, in my submission, this makes it absolutely clear that this wording requires a manifestation of the disease and not just an occurrence, because otherwise, neither party to the policy could be sure that an occurrence of the disease on the premises had been experienced, if I can use a neutral word there, by a visitor or employee, as opposed to any of the other people, however many there may be, appreciating my Lord Justice Popplewell's question earlier, that had been experienced by a visitor or employee, as opposed to any of the people who do not fall within these particular categories. And in this respect, the insured might be able to show that the disease occurred at the premises, or even that the disease was present in at least one of several people at the premises. But it requires the disease to be experienced by at least one of those people with particular characteristics that qualify them as a visitor or employee in order for there to be cover under our clause, under the Mayfair clause. And to take a real-world example, my lords, and I'm afraid it's not very picturesque, but were a local authority to take samples of sewage outflow from a particular premises to see if COVID-19 was present, the analysis of that wastewater might establish that someone at the premises had COVID-19 at the material time. However, in order to ascertain whether that someone was a visitor or employee, rather than, say, the owner or the managing partner or a director, it's necessary for the disease to have been manifested in some way, either by the visitor or employee exhibiting symptoms or having been diagnosed with the disease. A manifestation requirement is, we say, therefore essentially a practical necessity of the suffered by any visitor or employee wording in the Mayfair disease clause.
I don't know how realistic an example that is, but presumably, presented with the results of that analysis, the insurers would say that even though there were 200 people in the nightclub and only 10 employees on duty, they couldn't prove that it was the right category of person, because the director might have been in there.
Well, but the questions of proof are very much central to why we say this is a manifestation wording, and it's possible to come up with all sorts of hypotheticals, I would imagine. It's fairly unrealistic to imagine anyone doing sewage sampling from a nightclub in the first place, but in a sense, any occurrence wording is always going to face difficulties of proof. I recall an exchange earlier in these proceedings between Mr. Keeley and my lady, Lady Justice Andrews, about whether it was his case that one necessarily had to be necessarily aware of a case on the premises. There are difficulties of proof with occurrence wordings, but in my submission, that's a point in my favour, which means that this, in a small business commercial policy like this, is more likely to be a manifestation one, which is frankly simpler.
Well, I was really just testing your argument because the example you gave was where it can be proved for a fact that somebody had COVID on the premises, but not necessarily whether it was a visitor or an employee or somebody who falls within the relatively narrow category of people outside those. But anyway, there we are.
It would be. If one could go further, I mean, if in the sewage example, if one could conduct a genetic analysis and link it to a particular person, then you would have effectively diagnosed that person, which is what we say the clause requires. And my lords, my lady, for those reasons, AXA respectfully submits that the judge was wrong to find that suffered by any visitor or employee at the premises was effectively to be equated with sustained by any person, and therefore constituted an occurrence wording, and should have held that the Mayfair disease clause was a manifestation wording of the type set out in Declaration 7 to the FCA test case. Now, my lords, I apologise, I've been 16 minutes, so I think I've failed to earn my brownie point, but unless I can be of any further assistance, those are AXA submissions.
Thank you very much. Yeah, let's enforce it now, is it?
My lady, my lords, can I take you first, please, to the core bundle at page 455, which is the Mr. Justice Jacobs' judgment at paragraph 343. He summarises there what AXA's argument was before him in relation to ground one of this appeal, which of course is on the meaning of the word suffer. And he says as follows: the Mayfair insurers argued in summary that suffered by was not to be equated either with an occurrence of the disease or a person sustaining the disease, nor with manifestation of the disease. So before I get into the substance of the argument, I wanted to make the point that in the court below, Mullen and Friends was certainly not pursuing manifestation as their case. It was, as my learned friend Mr. Lane has already said, my alternative case in the court below. And what AXA was pursuing in the court below was a meaning of manifestation, but without any possibility of diagnosis. So AXA was simply saying manifestation where there had to be apparent symptoms, and diagnosis wouldn't fit the bill. And so, as far as the Supreme Court's declarations were concerned, particularly Declaration 7, AXA was arguing something effectively harder to prove than Declaration 7. But as to the substance of the argument, the judge dealt with that at paragraph 356 by saying that, by contrast, if the word suffer were to denote the subjective experience of the visitor or employee, they would be an uncertain threshold for the identification of the point at which the subjective experience was sufficiently bad to mean that the person was suffering, or in other words, there's no objective standard of misery along a scale which perhaps has the stoic and the unsneezing at one end, and those who fare far worse at the other. But more important than that, my lady, my lords, I say that the way in which the court ought to approach the definition of suffered by is by looking at the words. That's the starting point, the language in the contract. And the learned judge below took the view, of course, that suffered by meant sustained or occurred. And in my submission, that's an obvious view to come to, because the word manifested carries within it a fairly obvious requirement that something is manifest, as in apparent, and the word suffered simply doesn't. And so in my submission, the distinction is a fairly obvious one. The judge below quoted excerpts from the dictionary, and my learned friend highlights definition 10, to sustain injury, damage or loss, or to be injured or impaired. But in fact, if one looks at the other definitions, the other 9, definition 1, to have, brackets, something painful, distressing or injurious, inflicted or imposed upon one. So to simply have something inflicted upon one is enough, according to that definition. Similarly, so 1C, bodily injury or discomfort. There's nothing there that suggests, except by something of a stretch, that the injury or affliction has to be apparent to anybody. Again, the other definitions are the same. They provide alternatives and usages of the words that we all know already. And it's a short contractual construction point, and I submit that the judge below was quite right to take the view that suffering meant occurred in accordance with Declaration 5. My lady, my lords, I move on to the other Mayfair specific point, which is visitor or employee. My learned friend makes the point that the words visitor or employee affect the approach to causation. And the way I understand this to be put is that it is a similar argument, essentially, to the other 2 arguments in relation to whether causation applies either specifically to a radius but not external to it, specifically to the premises but not external to it, or in this case, as my learned friend is, I think, arguing, specific to a category of people which create a link with the premises, and therefore that causation per para 212 of the Supreme Court's judgment doesn't apply in the same way. In my submission, that must fail for 2 reasons. Essentially, the 2 reasons given by the trial judge below. The first is a construction point, which is as to whether the words visitor or employee effectively amount to person. And in my submission, the judge was quite right to say that visitor and employee, in the case of a corporate entity like Mayfair, do amount to person. It's very difficult to see in the context in which this contract was agreed between the parties any other category of person who would make any material difference to the overall approach to causation, except possibly in the case of an individual owner, which Mayfair isn't, of course, where they're on the premises perhaps doing their VAT return or something like that. But I can go one step further than that, if I may, and say that the judge was quite right to say it didn't make any difference. And one reason why it doesn't make any difference with reference to an example is that if one decides to narrow the category of visitor or employee for the sake of argument, one can see that even then it doesn't make a great deal of difference to the way in which causation must apply under paragraph 212. If, for example, the category was narrowed to employees known as Joe Bloggs at the premises, something very specific indeed, the argument still applies that in fact the way that the parties agreed this contract was that they were providing cover for diseases that spread rapidly and widely, in other words, pandemic diseases, and that they intended when they entered into the contract that the response of the government to such a disease would be generalised in nature, and in accordance with para 212 would therefore include, if proved, Joe Bloggs, an employee at the premises, along with all of the other concurrent causes of COVID-19 across the country. So in my submission, it's a very wide category, and even if it were narrow, it wouldn't make any difference anyway to causation. As far as words of localisation are concerned, I don't think my learned friend's actually putting it in this way. I think my Lord Justice Mayles confirmed that with my learned friend. But if there is any suggestion that visitor or employee amount to words of localisation in some way to, in the Corbyn and King sense, make some direct connection with solely the premises, in my submission that simply doesn't work. on the basis that one would expect there to be rather clear words used by the parties in order to do that, rather than simply inferentially by reference to visitor or employee. My lady, my lords, the other points raised in relation to those first two grounds by my learned friends that are, for example, specific parts of the Mayfair policy schedule which refer to the use of the word sustain. Before I move on, I should just deal with that point briefly. I set out in my skeleton argument the way in which that falls down. The references that my learned friend makes to the word sustained being used in the Mayfair certificate, I've listed at my paragraph 41. And for example, clause 9G, damage which may be sustained whilst the property insured is actually being worked upon or is under any process indirectly resulting therefrom. Clause 18G, damage which may be sustained while the property insured is actually being worked upon or is under any process. And then other references to underwriters will pay to the insured the loss sustained in respect of outstanding debit balances. These are just a scattering of the use of the word sustained in a different context to the suffering of disease. And my learned friends made very clear that one has to look at suffering in the context of suffering from a disease. So in my submission, those don't take matters any further. In relation to visitor or employee, in my submission, the approach that the judge took below, it simply didn't matter, was entirely right. And so I invite you to dismiss grounds 1 and 3 for the reasons I've given. Overall, though, grounds 2 to 4, including visitor or employee, deal with the major issue of causation. And in that respect, I gratefully adopt the submissions put forward by my learned friend Mr. Kramer in relation to the main causation issue. And I also adopt the submissions put forward by Mr. Gruder insofar as they relate to the Mayfair causation issue, as well as in particular what my learned friend Mr. Kramer said in his supplemental skeleton argument in relation to the points raised by AXA in relation to Professor Stapleton's scholarship and maps. But I'd just make a few points rather than repeating everything that's come before me. My learned friend, in relation to maps, made those arguments at some length to the judge below. And can I take you, please, to page 432 of the core bundle, paragraph 235. Where the view that the judge below took of it is that this argument is certainly imaginative, but I have no hesitation in rejecting it. It was no part of the reasoning of either the Divisional Court or the Supreme Court that the concurrent cause analysis was appropriate, because an equivalence between the radiuses referred to in the various policies and the known cases in the country, or that it was in some way based on the maps which Mr. Edelman has produced in the course of his final submissions. My lady, my lords, the maps argument is really a rehash of the argument that is run more generally in relation to causation and the at the premises issue. What's being said, or has been said, is that the size of the radius was the key thing in the decision of the Supreme Court, as opposed to what has been said by the insureds in this case, which is that the parties contemplated when making provision for cover for pandemic disease that the authorities' response would be general because it was to cover diseases that spread widely and rapidly. And that's the key point. It's made as a point at the end of Mr. Kramer's skeleton argument. But this point about maps is really a rehash of that. What it seeks to do is to persuade the court that the the size of the radius, effectively, is what matters. The wide area of the policy's geographical area is what led to the Supreme Court's decision on causation. In my submission, it wasn't. What was key in that, as the judge below found, was the reference to the type of disease covered. There are various problems with the MAPS argument, of course. Firstly, there are issues such as the lack of equivalence in exact terms between the circular areas superimposed on the United Kingdom and the local authority areas. There are gaps between the circles that one could make points about. So there isn't an exact convergence anywhere between those two things, and what it simply seeks to do is draw a very general comparison between these large radii and the conclusion of the Supreme Court on causation. In my submission, that doesn't take matters very much further because it's all to do with the disease. My lords and lady, in terms of the issue to do with health and safety, I should simply say that while there is a reference to the health and safety requirements, I think in the certificate, the judge below held that in relation to health and safety, it was a duty that employers and businesses of this sort in relation to policies have to their employees. Not contractual language, it's not a contractual term, and it doesn't take matters any further. There were points, my lady, my lords, raised in relation to prevalence. My lady, Lady Justice Andrews has already made the point about the SAGE minutes showing a doubling every 5 or 6 days. And of course, well, one can't exactly say that might be millions straight off. It certainly leads to that in a fairly short period of time, as any kind of exponential increase does. I'd only point out, in addition to that, in relation to my own friend's argument about that the Supreme Court made declarations at page 224 of the authority bundle in relation to prevalence, declaration 8.2F, which made it very clear that one could prove COVID-19 in accordance with the terms of the policy, as it says at F, given the likely true number of cases of COVID-19 in the UK in March 2020 was much higher than that shown in the reported cases. An undercounting analysis, albeit absolute precision is not required, to discharge the burden of proof to demonstrate the likely number of actual cases of COVID-19 in the relevant policy area. So there's a declaration that the Supreme Court provided which gives a very clear indication that in fact the reported cases were only part of the story, and that in fact the likely true number of cases was, quote, much higher. There is also reference, as I think your Lordship's already alluded to, the reference by Lord Briggs to 1 million cases, and further a reference in the divisional court case to the authority responding to all cases across the country. So the suggestion that in some way the factual basis for the Supreme Court's decision was that it was to reported cases is simply not made out by what the Supreme Court said. I'd only briefly end with the point about Professor Stapleton's scholarship, because it's raised in the supplemental skeleton argument. What is said about Professor Stapleton is that essentially her article in relation to contribution formed the basis for the Supreme Court's conclusions at paragraph 212. My own friend Mr. Kramer makes points about that as to AXA's misunderstanding of what Professor Stapleton said. I simply make the point that the Supreme Court said what it said at paragraph 212. It read, carefully considered Professor Stapleton's scholarship, and if there was some other element to the test that we're not aware of, the Supreme Court surely would have said it. My lady, my lords, unless I can assist any further, those are my submissions.
Thank you very much. Back to you for a reply, is it?
Lords, I'll just be repeating myself. I don't have any
All
points in response, unless your Lordships have any points.
Right. Okay, I think so. Thank you very much. So, what do you do now? You want to...
It's Why Not Bar. Will be at 2 o'clock, I think.
That's Mr. Christie.
Yes, we're indeed at 2 o'clock, my lord. In any event, we would have to have a movement of papers, so if we can...
Yes, all right. Well, we'll adjourn now to 2 o'clock.
You are able.
I think it's 15 minutes.
Yeah.
Probably should say
Right, he's coming.
I used your objective. Yes, this is almost